Welcome, everyone, again to another episode of Spilling Tea. I am your host, Tiffany Daniels. And, folks, we are covering Part 6 of the Judge Rotenberg Center on trial for back in 2012. Now, before I go on continuing this, I was made aware this morning in regards to comments made by Richard Dawkins in regards to how it is immoral for a parent to give birth to someone with Down syndrome. Well, Mr. Dawkins, people with disabilities have the same right to life as everyone else. Period. My nephew, Estes, he has a right to life. And I won't let anyone make him feel less because he was born with a disability. His aunt here was also born with a disability, and I'm not less than anyone. I'll take on any so-called neurotypical person you want to put up against me in whatever thing that you would like. And then come and tell me that I didn't deserve to live. Go ahead, I dare you. This is the same mentality that it surrounds places like the Judge Rotenberg Center, who use inhumane means to try and make us normal. See, things like this is what is dangerous, folks, because when you have this mentality, then that excuses any kind of torture or abuse towards people with disabilities as long as you call it treatment. So without further ado, and on that note, let's go ahead and start taking a look at exactly what that looks like as we again go back to the Judge Rotenberg Center trial back in 2012. Now, as always, I will be including the link to the article in the description, as well as the close down the Judge Rotenberg Center petition. Please sign, folks. All right, let's get to it. Witness testimony in the medical malpractice trial over the use of electric shock and restraint. Oh, let me stop. Sorry. Disclosure. Trigger warning. What you are about to hear includes detailed descriptions of torture and abuse of a disabled person. Please, if you have children at home and you are watching this video, please have them go into another room. Thank you. Okay, so now let's start over. Witness testimony in medical malpractice trial over the use of electric shock and restraint on Andre McCollins at the Judge Rotenberg Center concluded on Friday, April the 20th. The examination of the JRC founder, Dr. Matthew Israel, and defense expert witness, Dr. Lloyd Price. Before the jury entered and the trial resumed, the parties approached the judge to make motions for approximately 10 minutes out of earshot of observers and cameras. The content and outcome of these motions was not clear from what followed. Although Dr. Israel had briefly been on the stand for the previous afternoon, the defense decided to break up his testimony in order to call Dr. Price to testify first. Dr. Price identified himself as a board-certified forensic and child-adolescent psychiatrist. He stated that he had worked with autistic children and others with developmental disabilities, both in his private practice and at McLean Hospital, a psychiatric facility in Belmont, Massachusetts. He also teaches at Harvard Medical School. As a forensic psychiatrist, he had testified in many other trials, often as an expert witness for insurance companies and civil suits. In preparing for this case, he had reviewed Andre McCollins' records from hospitals and residential treatment programs, including JRC, as well as the entire video footage from the incident and the opinions of the plaintiff's experts, Dr. Whaley and Dr. Duckworth, the latter who never ended up testifying. The first thing Dr. Price did in testifying about the case itself was to try and establish that Andre was not truly autistic. Oh, dear God, not another one of these. He stated autistic children do not develop communicative speech. How is he a psychiatrist? It's a spectrum, dumbass. This is what I mean. When people like this, with their medical degrees, will sit there and tell you you're not really autistic because you communicate and have a social media page, is the height of complete stupidity. It is a spectrum with varying degrees, and people are affected in different areas. My sensory issues, for example, tend to be more pronounced, whereas my ability to communicate with others was not so much affected, although it was affected to an extent, especially if you had been around me when I was younger. Just saying. Nor do they interact with other people unless they have to. Also, complete bullshit. Based on his reading of the records, Andre met neither of these criteria. You're an idiot. Read your DSM-5. How is he a psychiatrist? And thus he had concluded that the programs and medical facilities had diagnosed and referred to Andre as autistic were wrong in doing so. Again, you're an idiot. The DSM-5 had already gone through all its channels at this point. In 2012 was when they first really had in the DSM-5 what they used to diagnose us. You will see on there autism spectrum disorders, which will show it is a spectrum. People like this doctor want to say that unless you have the classic Ganner's autism, that you're not really autistic. It's a load of bullshit, and they love to use it in order to marginalize people like me. But we'll go ahead and move on. That was just a little bit of a history lesson for you. Later in his testimony, he would go on to diagnose Andre as having schizoaffective disorder, which he characterized as a combination of mood disorder and schizophrenia based on hallucinations and hypnotic states that Andre experienced. Andre's diagnosis of psychosis, not otherwise specified, only supported this diagnosis further in his estimation. Thank God you're not my doctor. He moved on to discuss psychosis and catatonia, speaking generally about the conditions. Specifically, he stated that although a psychotic individual is unable to correctly to perceive what's happening around them and may be delusional or have hallucinations, psychosis itself is cyclical, and an individual may at times be symptom-free. A catatonic state, according to the witness, is not necessarily indicative of psychosis and can have other causes. As far as Andre's catatonia was concerned, Children's Hospital Boston had diagnosed him with mild catatonia. This was inaccurate according to Dr. Price, who I'm glad, again, is not my doctor, as in his opinion, which is completely uninformed, Andre did not meet the criteria for a catatonic state. Then what does he meet in your criteria, Dr. Price, since you're the freaking god of diagnoses? Sorry, folks. Sorry. He attributed Andre's dystonia, or muscular rigidity, to the administrations of Hadl that Andre had been given during his hospital stay. Furthermore, he relied on a doctor's comments in testifying that part of Andre's unresponsiveness and lack of movement had been voluntary rather than symptom of any condition. Or it could be due to the trauma that had been forced upon him by being shocked over 30 times. Just a thought. Defense attorney David O'Connor returned to the subject of the psychiatric medications and side effects next. According to the JRC, it had been recommended sometime on the day of the incident that Andre be put back on Risperidone. Despite the JRC's own recommendation of this, the attorney went on to elicit testimony from Dr. Price that, though it was not necessarily more likely than not that Andre might develop permanent side effects, such as tardive dyskinesia, from the use of Resveratrol, it was possible. Furthermore, the witness said, based on the records, the medication had not eliminated all of Andre's behavioral problems. Also, if the JRC had put Andre back on Resveratrol on or shortly before the date of the incident, the doctor said that it would have taken anywhere from a week to 6 months, and likely a few weeks to take effect. Then why did you take it off him? Why did you make him do shocks instead of medicine? God, I hate people. This is an idiot parade today. I know more about autism than this doctor, and I don't have a doctorate. The discussion turned to Andre's state and behavior on the 25th of October 2002. According to Dr. Price that morning, Andre had been physically assaultive, a nicer way of saying violent. He went on to repeatedly categorize Andre as oppositional and angry in his behavior that day, between his unresponsiveness to questions, yelling and screaming, struggling while being restrained, and verbalizations such as no, help, ow, and that didn't make sense. Again, how's this guy a doctor? Hello. Okay. If you're getting shocked, wouldn't you be oppositional and angry? I would be. Saying. Unresponsiveness to questions. Again, you just shocked him multiple times. Screaming and struggling is violent? Really, trying to get away from your abusers is violent. Okay, Dr. Price, I guess your name is A.H., isn't it? Hello, Dr. A.H. Freaking hell. Thus, he concluded Andre was not in control, had been resisting commands, and had a history of aggression, was an acceptable emergency response. A history of aggression. Being oppositional and angry for being shocked, yelling and screaming because he's in pain, struggling while being restrained, again, he's in pain, and violent for saying no, help, ow, and resisting commands. These people are sick. Oh my. We'll get through this, I promise. I thought this was going to be a quick read through today, but apparently with Dr. A.H. on the stand. As far as Andre's reactions to this and the shocks he received that day, he, to Dr. Price's eye, did not appear to be frightened or scared. What? So saying, ow, no, help, please help me, no, and screaming does not, to you, in your expert opinion, show fear? The hell am I reading right now? His reactions, the doctor said, had been disproportionate and puzzling. I can explain them to you. As normal reaction to the GED is not to scream. Really? Is that a fact? Because if someone's shocking me with enough volts to be 10 times more powerful than a police taser, I tell you what I'm going to do. I'm probably going to scream. After all, Andre had received shocks before and had been, in Dr. Price's estimation, used to them. You shouldn't have to be used to them. The witness further pointed out that Andre's screams were sometimes not a reaction to his being shocked, but instead to the sounds around him, such as that of cell phones ringing or someone testing or using a GED elsewhere. Oh, dear God, forbid he scream in symphony with another poor kid who's being tortured. As for Andre's full-body tense-ups, the witness' opinion was that they could have been a manifestation of a number of things, including anger, physical reaction, or fear. Or maybe and this is just from a medical point of view, from things I have observed, it's due to the fact he's being shocked. Shock causes muscle tense-ups. How? As a doctor, do you not know this? I swear to God, I'm one of these days, I'm just gonna bring my mom on here to maybe, I don't know, talk to some of these people. Because even as someone who's never been a doctor, even she has better knowledge than this. Just saying. Based on his review of the Children's Hospital Boston records, Dr. Price stated as early as the third day that Andre had been in the hospital, he was near or at baseline. Yes, because that's good enough. Oh my God. These records indicate that on the 5th day of hospitalization, Andre was visited by and was in fact interacting with staff from the JRC. Oh my God. So you're going to bring his abusers into his hospital room? This is sick. This is horrifying. Dr. Price went on to say, in his expert opinion, Andre had been baseline upon leaving the hospital, and discussing how Andre had been immobile shortly afterwards, requiring furthering hospitalization and medication. He said that was difficult to relate. Oh my God, how are you a doctor? To what had happened to Andre at the JRC. Really? Really? Okay, Karen. Furthermore, the anxiety that Andre had been experiencing got better, while the psychotic symptoms he had been exhibiting that had led up to his hospitalization had been stereotypical or usual enough for Andre. Gee, could be because you're torturing him. More recent records suggest to the doctor that Andre made significant improvements at subsequent residential programs in that he became communicative, had far fewer aggressive episodes, and might possibly be placed in a less restrictive setting in the near future. So, oh my God, it could be, maybe, I don't know, they're not abusing him? Thus, he concluded that Andre experienced no permanent damage that was casually related to his treatment at the JRC. He will never get out of an institution now. He was on one medication, one, Risperidone. He's now on multiple medications and will never be able to live independently now. And you want to talk to me about no permanent damage? Again, oh my God. The attorney attempted to counter Dr. Whaley's testimony that a psychotic person could not learn from the use of aversive with that of Dr. Price, who stated that he disagreed with Dr. Whaley on this point. You can train a dog, the witness said. Did he just compare Andre and people like him to a dog? I mean, I know I shouldn't be surprised, but this is from a medical professional, folks. Holy shit! The witness said before adding, not saying that patients are like dogs. Sure you didn't. Sure you didn't. You just highly insinuated it. In fact, he said that based on a review of literature on the subject, there was nothing in support of Dr. Whaley's opinion. Really? Really? Because I got a lot of doctors out here where I live that would beg to differ. And that there are many behavioral programs used on intellectually disabled autistic and psychotic patients. Okay, that's just horrifying. Where they torture us in other behavioral programs? Fabulous. Ah. The direct examination closed with a discussion of the treatment Andre had received immediately after the incident. Dr. Price stated that it had not been medically necessary nor indicated for Andre to have been transferred to the psychiatric hospital, and that JRC had been able to handle the situation without doing so. Really? Because he could have died. I know, I've seen the video. I've been around enough hospitals to know. Specifically, they had given him a rectal administration of Valium on Friday. Oh my God. For the purpose of sedating him and reducing his anxiety. You want to know what would have reduced his anxiety? Not shocking him. Oh my God. Both the attorney and the witness, however, classified the treatment he received at Children's Hospital Boston as chemical restraint, as he was giving Haldol and a number of medications to make him more manageable there. That's not the purpose. God, I hate people. In the beginning of cross-examination, Platon's attorney, Benjamin Novotny, asked Dr. Price about his work with autistic children or those with other pervasive developmental disorders, and the doctors answered that currently none of his patients were autistic, nor are they children. Mr. Novotny also established that in the last year, Dr. Price worked only 20 hours at McLean, and that the last time he worked with a children's unit was in 1987. It shows! He further elicited that Dr. Price had spent about 10 hours reviewing all the records for this case, and his total preparation time had been approximately 20 to 25 hours. Mr. Novotny proceeded to go through Andre's medical records, finding mentions of Andre's diagnosis of autism, or, more generally, a pervasive developmental disorder. These diagnoses, the attorney pointed out, were made without there being a lawsuit in progress, and had not been made by people hired, as Dr. Price was, at $400 an hour to do so. The witness held his ground, insisting that these various other doctors had to come to the wrong conclusion, even when he was asked whether he could really expect to accurately diagnose Andre years later without ever having met or talked with him or his mother. And it's a spectrum! Get with the program! This was a walkthrough of the records, also revealed that in diagnosing Andre with catatonia, the Doctors Children's Hospital Boston had listed PTSD shocks as the cause. Thank you! Somebody with sense. Dr. Price confirmed that he knew the records that Andre was scared of the new situations and that he believed that the people were out to harm him. Oh gee, I wonder what gave him that idea. Still, he spoke to Andre's oppositional behaviors, namely seemingly reluctant to move along and sit in his chair after coming into class. Gee, again, I wonder why. He conceded, though, that Andre had not been oppositional when staff had removed the restraint helmet at the beginning of the day, and when Andre had been sitting at his desk, and also said that he was not sure if Andre was being oppositional while staff was removing the restraints that he had entered the room in. He admitted when asked that some of Andre's screaming that hadn't been in response to being shot had been instead in response to staff removing his pants and placing him in a diaper. However, he continued to characterize Andre's reactions to how he was treated that day, including his tensing up and crying, as angry and oppositional. How? Tensing up and crying as violent. Oppositional. This is sick. This is disgusting. This is horrifying. Thank God none of my doctors came from here. Even when Mr. Novotny brought up how the use of aversives that day had been well above anything Andre had ever experienced in his life, the witness insisted that Andre had predominantly angry and oppositional. Maybe you should apply for a job here, Dr. Price. When confronted with a quote from Dr. Haynes' testimony that it was impossible to tell if the tense-ups were caused by anger or fear, he responded that he would have had to see the quote in context. This is sick. When Mr. Novotny asked him if electric shock was a cure for psychosis in any amount, Dr. Price admitted that it wasn't. However, he asserted that it was ethical. Ethical! Ethical! Ethical to strap someone down and shock them all day. Oh my. Lock them all up. Put them all in jail. Put them all in jail. Or even better, let's put Dr. Price on a 4-point board and shock him over 30 times and then let him tell us whether it is ethical or not. If part of the well-thought-out treatment plan. Well thought out. Slightly later in the cross-examination, though, Mr. Novotny asked him if, in fact, the GED had been working in addressing Andrei's behavioral problems, to which he answered no. And then using it is just to hurt people. Mr. Novotny pressed him on this, asking if the 13th, 29th, 28th, 25th, or 20th shock had been successful, which finally caused him to say none of the shocks that day appeared to be changing his behaviors, either as individual interventions or overall. Thank you. The cross-examination moved on to the care or lack thereof that Andrei had received over the last weekend he was at the JRC, with Mr. Novotny presenting Dr. Price through questioning with the facts that Andrei's condition had continued to deteriorate, that he had become unresponsive and dehydrated, and that he had stopped eating. All things that witnesses agreed were true based on the record. Dr. Price further confirmed that the only reason that Andrei had been transferred to a hospital for treatment was because Andrei's mother had insisted on it herself. Good. And had, in fact, come to the facility to take her son to the hospital. In JRC's defense, he said that Andrei had been given treatment there in the form of sedatives, but that they could not give him hydration. Furthermore, he said it had not become necessary to take Andrei to the hospital until he had become dehydrated, which he was only to some degree when he arrived at the Children's Hospital, Boston. Oh my God, what is this? As Andrei's psychological condition at the hospital, Dr. Price attributed to the fear he was showing due to his usual discomfort with new environments. Or it could be the nightmare he just went through. The witnesses admitted that Andrei had been unresponsive but not catatonic, and went on to say that acute stress response has no real medical meaning as a diagnosis. Mr. Novotny concluded the cross-examination by asking Dr. Price why, if he had been so convinced that the doctors at Children's Hospital Boston and other care facilities had gotten Andrei's diagnosis all wrong, he hadn't told anyone or otherwise attempted to report it, as it raised serious concerns about the competence of the doctors who diagnosed Andrei. Dr. Price responded by saying essentially that it had happened too long ago and there would be no point. God, what an idiot. Or maybe you just didn't want to be made to look the fool, freaking Mingala. On redirect, Mr. O'Connor, through questioning, pointing out that some of the mentions of Andrei's being autistic were simply notes by nurses, not diagnoses made at the time by doctors. It was made later. Really? These mentions, according to Dr. Price, were based on the patient history provided to the hospital by Andrei's mother upon his arrival to the hospital, and there had been no clinical assessment of diagnoses she had reported. Yeah, there was. I know, I've seen the court documents. Mr. O'Connor attempted to contrast this with how Dr. Price reviewed all the available records before reaching a conclusion about how Andrei should have been diagnosed. In countering what Mr. O'Connor characterized as Mr. Novotny's pop quiz of Dr. Price about the incident itself, the witness said that Andrei had been calm for periods of time immediately following some of the shocks. Furthermore, he justified the use of shocks in response to Andrei's being oppositional, stating that behavior starts as oppositional can escalate to aggressive types of behavior. Let's shock him into submission. Let's torture them into submission. Torture them until they cry. Torture them until they stop moving. That's what that sounds like. That's what that sounds like. Wait, I gotta breathe. Glad these guys were never my doctors. Oh my God. They should be all put on the GED just for a day and see if their yelling, screaming, and tensing up is oppositional. However, he admitted that there were slices of time shown on the tape where what happened did not perfectly fit in with his overall opinion. Finally, in a brief recross examination, Mr. Novotny elicited testimony from Dr. Price that the JRC staff had kept Andre in a very sedated condition over the weekend following the incident for the purposes of controlling him, and had only once on the afternoon of the incident itself had a doctor evaluate his condition. Thank you. After the end of Dr. Price's testimony, Dr. Israel returned to the stand, beginning this part of his testimony by explaining the difference between psychiatry and behavioral psychology. Specifically, while psychiatry involved great use of psychotropic medication, behavioral psychology relied on environmental changes to address problem behaviors. This, he said, could overt behaviors such as sitting and throwing things, and covert behaviors such as thinking and imagining and talking. Oh, son of a bitch, we're going to be going through Dr. Israel. I don't usually do this on my channel, folks. I'm going to take a little brief break, just a second. Warning, this is about to get a lot worse. He went on to discuss the JRC and its population, beginning by mentioning the program's near-zero rejection policy, which he said meant that it dealt with the hardest cases. Here's his apologetics. Here we go. Students who couldn't be served in any other setting, says you. He divided the JRC's student body into those he considered lower functioning, including autistic students and those with pervasive developmental disorders, and those he considered higher functioning, namely students whose primary diagnoses were emotional and behavioral disorders. Some of them, as far as he knew, were diagnosed with psychiatric disorders. However, he said that all the students at the JRC had behavioral disorders. It's not a behavioral disorder. It's a neurodevelopmental disorder. How are you having a license? The JRC's mission, as he put it, was to help those children and young adults to change their behaviors and to live as dignified and productive a life as possible. You ableist, evil son of a bitch. 1 second. Sorry, back. As executive director in 2002, Matthew Israel had been responsible for all of JRC's departments and operations. He did, however, not directly treat any patients in this role, and as he said later on during direct examination, he had not been involved with the development of Andre's treatment program. Instead, he described himself as having been involved in whatever work was of highest priority at JRC at any given time. which had at one point included dealing with Andre on the 25th of October 2002. In discussing the behaviors for which Andre had been shocked, Dr. Israel said that full-body tense-ups were listed on the JRC literature that was provided to parents of potential students as possible target behavior that the program would address through the use of adversives. He described what a tense-up would involve and look like to the jury, but said he could not remember having observed specific instances of Andre or other JRC students tensing up. This guy is sick. Fucking sick. As to why a tense-up was a target behavior in the first place, he said it was considered dangerous. Oh my God, seriously? And that it could cause an individual's blood pressure to rise. Then stop shocking him. If you don't shock him, there won't be involuntary muscle spasms. There won't be involuntary tensing of the muscles. God, I don't even have a medical degree and I know this. On the subject of the incident itself, Dr. Israel said that much of his knowledge was based on having received information from other people on the day it happened and from having seen the entire video after the fact. His own involvement in what happened had begun when Dr. Robert Van Hine and the JRC Director of Programming, Sue Parker, came to his office to tell him about the number of the shots that Andre had received and about how Andre wasn't responding to them at approximately 3:30 p.m. that day. It's called burnout. His body is in exhaustion. Imagine being shocked to the point of beyond exhaustion where you can't even physically react anymore. That's the kind of horror we're dealing with. Upon arriving in the room in which Andre was being restrained, he talked with the members of staff to find out more and see if he could help. He wasn't the usual Andre, Israel said in the testimony. It just seemed like he was in such a different state. Gee, I wonder why. He elaborated by saying that the staff had been unable to make behavioral contracts with him in order to change how he was acting, and that as a result his behavioral program needed to be changed to that meant for something with much more functioning level. Let's shock him some more. Let's shock him some more. That's your answer, right? Right? Just say it. Let's just torture him some more. We'll torture it out of him. Right? Right? Because that's what I'm hearing. Dr. Israel had been present for the JRC's doctor's medical examination of Andre later that day and reported that Andre had not been dehydrated then. Lies. And that there had not been anything to suggest, as far as he knew, that Andre needed to be taken to the hospital at the time. Lies. In fact, the doctor examining Andre had encouraged things to and about Andre and his condition. Over the weekend, JRC's round-the-clock nursing staff would have been in charge of Andre's care, and Dr. Israel himself had not been involved. He had also not made the decision to transfer Andre to the hospital on Monday, as that had been a treatment decision not requiring the executive director's approval, but he said that he would not have opposed the idea if it had been presented to him beforehand. He discussed both with Mr. O'Connor and as part of the brief questioning by Dr. James Riley's attorney, Edward Hinchy, his disagreement with the plaintiff's expert witness, Dr. Whaley's opinion that someone with Andre's diagnosis could not learn from the use of adversives. In fact, most of the literature, including recent and, in his opinion, credible literature on the use of adversives, he said, involve patients with psychotic disorders or intellectual disabilities. No. 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 If you come for my nephew, you want to see oppositional and violence? Oh my God. He testified that a higher level of intellectual functioning was unnecessary for behavioral modification to work, and in fact, behavioral therapy is the treatment choice for autistic children at this point. This man's sick. 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 Give me a moment, folks. I'll be right back with you. I try not to hate anyone, but I will hate Matthew Israel until the day I die. All right, let's move forward here. I'm going to try to read through this quick. After Dr. Israel's direct testimony, the judge heard a motion outside the presence of the jury on the issue of how he described himself as retired from his position as executive director of the JRC while on the stand. Mr. Novotny argued that this was misleading, given the fact that he had actually been forced to resign after pleading guilty to destruction of evidence pursuant to a state investigation last year. That was the tape, by the way. He wanted to destroy the tape. Sick son of a bitch. He went on to say that the picture painted by the defense about the circumstances of Dr. Israel's leaving the JRC couldn't be further from the truth. Mr. O'Connor responded by saying that retiring was legally the same as resigning and threatening that if Mr. Novotny brought up the forced resignation, he would bring Cheryl McCollins back up on the stand to testify about the previous lawsuits she had filed against other care providers. The judge reminded Mr. Novotny that he was precluded from discussing the circumstances of Dr. Israel's resignation based on the previous motion, and said that in any case, she didn't see the relevance of it to this case. A second issue that came up out of the presence of the jury was the issue of the JRC's last witness. The last expert that the JRC had expected to testify had to return to Canada that afternoon, and instead the JRC wanted a direct care worker who had been there on the day of the incident, Casey McCauley, to testify and said. Mr. Novotny objected, and that the part of the testimony that Ms. McCauley would provide would be about a prior incident where Andre was aggressive, and that would shift the focus away from what happened to him in the incident at issue and onto Andre's aggression in general. Mr. O'Connor defended the choice of witness, saying that he wanted her to testify to show that there was a reason for concern on the 25th of October 2002 for him not wanting to remove his coat, ladies and gentlemen. For him not removing his coat. This is their records. Their records. And adding the JRC has been villainized here. They should be. They should be. You are the villains. The judge postponed the motion for the time being. After these motions, Dr. Israel returned to the stand for cross-examination. Oh my God. In response to what was said very early on in the direct examination the previous day about Dr. Israel's training, Mr. Novotny asked him if it was true that his mentor, B.S. Skinner, had never actually used adversives on humans, let alone children, but instead had only used them on pigeons, rats, and other animals. Dr. Israel confirmed that this was the case. He also admitted that his two own attempts at forming a utopian communities based on those proposed in Skinner's book, Walden 2, had failed. Gee, I wonder why. Mr. Novotny also asked Dr. Israel about the fact that 75% of the research that supported the use of aversive treatment was over 20 years old, to which Dr. Israel responded that politically it has become difficult to use skin shocks. Gee, could it be because I don't know. It's torture? The attorney also brought up how 8 out of 10 pro-aversive studies in more recent years were written or co-written by Dr. Ivar Lovis, a psychologist who later repudiated the use of aversives. Good for him. Dr. Israel dismissed this, characterizing Dr. Lovis and other mental health professionals' change in opinion as caving to political correctness. Or maybe they bought a clue. You should try it sometime. Maybe they didn't want to torture people anymore. In response to clarifying questions, he further explained his role as executive director at JRC, which involved overseeing all things related to the facility. This meant, according to him, that he had the ultimate and final responsibility, including legal responsibility for staff actions. Mr. Novotny asked Dr. Israel about the treatment provided at the JRC, eliciting testimony to the effect that traditional counseling is discouraged and is not provided to students regularly as its potential reward for target behaviors. Oh my God. Let's not find out what's causing the behaviors. Let's not dig and find out why they're upset. Let's just torture them. Torture them until they stop. I hate this guy. Dr. Israel said he didn't recall that the students had to earn or pay for counseling sessions through program points earned good behavior, and said he was not sure if that's currently a policy. He confirmed, though, that a JRC student seeking therapy session must write a business letter requesting it in addition to paying earned points. Saying that this helped teach students language, letter writing, and business practices. This guy. Finally, he testified that it was true that students did not receive counseling immediately after exhibiting problem behavior as to not reward them for it. As for the shocks, he confirmed that the first shock device that the JRC had used, the self-injurious behavior inhibition system, had lost its effectiveness, but the JRC had to redesign its own device after the makers of the SIBIS refused to develop a stronger one. Oh, jeez. Returning to the reasons for which Andre was shocked, Mr. Novotny attempted to get Dr. Israel to admit that Andre had not been shocked for aggressive behaviors, nor for antecedents thereto. When Dr. Israel denied saying this, Mr. Novotny showed him his testimony from his deposition before the trial, which had recorded him saying that tensing up was not a target behavior because it was aggressive so much as it could lead to a rise in blood pressure. Dr. Israel continued to deny that aggression was not an issue where full-body tense-ups were concerned. Seriously? Saying that it could be, and was just less of one than a rise in blood pressure. Oh my God. Referring to a part of Dr. Israel's direct testimony, in which he had stated that Andre's treatment program had needed to be changed in the light of the events of the 25th of October 2002, to reflect on Andre's unusual state of mind, Mr. Novotny asked him whether he was referring to the treatment plan that Dr. Riley designed and that Dr. Van Hein helped implement. Dr. Israel confirmed that he was indeed referring to the same plan. Mr. Novotny also pointed out a part of Dr. Israel's earlier statements, where he had said that, in his capacity of executive director, he had been involved with whatever was of highest priority at the JRC, asking them what had been a bigger priority early on the day of the incident than Andre, who had been restrained and shocked many more times than ever before. He further confronted Dr. Israel with the fact that Dr. Riley had asked him to evaluate Andre earlier in the day. Dr. Israel gave no direct response to this. When it came to his connection with Andre more generally, he testified that Andre was doing so well that Dr. Israel didn't feel the need to get too involved in learning about him or his situation. Mr. Novotny followed up on this, saying Dr. Israel didn't know the first thing about Andre, to which the witness answered that one couldn't expect him to know about what diagnoses he had or what aversives he was receiving. Wow. Get him, Mr. Novotny. Get him. Mr. Novotny asked him rhetorically how he could not have overseen the program and not know about the students in it. Mr. O'Connor objected, and the judge prevented the witness from answering. Finally, in response to Mr. Novotny's questioning him about it, Dr. Israel admitted that he didn't know what the JRC policy on the use of restraints and helmet was at the time of the incident. The head of the entire show, folks. Nor did he know the details of obtaining authorization for high numbers of electric shocks. The head, everyone. The head. Okay. Mr. Novotny asked Dr. Israel about Mrs. McCollum's withdrawal of consent for the use of the GED on Andre's arms. What was promised to her, the attorney said, was very different from what she got. In a response to a question about the staff's decision to put electrodes on Andre's arms, Dr. Israel said, "I would rather they had not." He admitted the JRC had not had her consent and thus had no authorization to do so. The attorney then asked Dr. Israel if it was true that warehousing, which he defined as putting someone on drugs, putting them in restraints, and leaving them, was against JRC policy, to which the doctor answered yes. When asked if it was true that Andre had been put on drugs at the JRC after the incident, he dodged the questions, saying that warehousing is long-term. Mr. Novotny countered, saying that the only reason Andre hadn't been warehoused over the long term was because of his mother's intervention. He then asked whether Andre had been restrained that weekend, to which Dr. Israel answered that he didn't know whether or to what extent he had been. He went on to answer the questions of whether Andre had received good care by saying that he thought JRC staff did what was called for under Andre's treatment program. Mr. Novotny asked them how many people he had shown the videotape in which Andre received this care to between the date of his incident and 2011, prompting an objection by Mr. O'Connor that was sustained by the judge. On redirect, Dr. Israel reiterated that he had not been involved in the developing of Andre's treatment plan. However, he nonetheless spoke about the psychiatric contradiction form for the use of aversives had come up earlier in this case. One would expect, Dr. Israel testified, that a psychiatrist filling out the form would make a more explaining why a given procedure was contraindicated. That is, the information would have reached the JRC's programming department. Furthermore, he said that the fact that combination aversive procedures were listed as an option for Andre's daily recording sheet meant that they could not be shown to the contraindicated through the student's records. Between these two facts, he concluded that the psychiatrist's failure to properly initial contraindication sheet did not mean that these procedures were not authorized at the time of the incident. Jesus Christ. A brief cross-examination established that not only were the combination interventions contraindicated according to the sheet, but the food restrictions placed on Andre through the contingent food program, food deprivation, for those who don't know, which did not involve withholding of food, but using food as a reward, insisted Dr. Israel. As a reward. ABA, everyone. ABA. Insisted Dr. Israel in response to Dr. Novotny's characterization of it. Using it as a reward is just as bad, dumbass. Oh my God. Whereas, well, for the lack of initials proving otherwise, Mr. O'Connor was prepared to ask a couple more questions of this witness, but abandoned this attempt when the judge made it clear she wanted to move things along. Once Mr. Israel stepped down, the jury was dismissed and the court held another motion on the issue of whether Casey McCauley, the direct care worker that the defense wanted to call as a witness, could testify. Mr. Novotny continued to object on the grounds that he had not had the chance to depose her, and thus had no idea what her testimony would actually consist of. However, he feared that it would be focused on Andre's history of aggression, which could only be used to garner sympathy for the defense. He asked the judge not to preclude the witness from testifying, but rather limit the scope of her testimony. The judge allowed the witness. and told Mr. Novotny that he could object to parts of her questioning or testimony if he so chose. The JRC mentioned the possibility of bringing in another witness, JRC's Director of Programming, Sue Parker. Mr. Novotny objected on the grounds that she would be called to talk about a document that she didn't author or fill out, ostensibly the psychiatric contraindication form. Again, the judge told him he could object to the witness testimony while she was on the stand if necessary. However, the judge seemed eager to end the case and forbade JRC from calling any more witnesses after this. In the end, Ms. Parker did not testify, and Ms. McAuley was the last witness on the case. Ms. McAuley testified that she had worked at JRC for 3 years prior to the incident and still works there. In 2002, she worked in quality control after working as a teacher shortly before that. She did not generally work with Andre, she said, and only come to the classroom on the day of the incident to check on things when his teacher had become uncomfortable with the prospect of taking off Andre's restraints. She had not heard what had happened on the bus that morning when she arrived and had only learned about it after the first time Andre was shocked in the classroom for not taking off his coat. According to her, Andre had been highly agitated, struggling with us, refusing to come out of restraints, engaging in tense-ups and yelling and screaming. Gee, I wonder why. She characterized him as having been aggressive and dangerous. You have him restrained, and he's dangerous? Psychotic Karen. When asked to describe Andre's tense-up, she said that in such a state he was kind of like the Incredible Hulk. She elaborated by saying when he tensed up, he would attack people, hitting, kicking, and punching them. I would do the same if you were shocking me. She talked further about Andre's aggressive behavior, in particular about one prior incident in which she had been involved, namely the first time that Andre had ever been shocked. He had charged at the staff around him, herself included, and attempted to bite her face. Good. I would have. He ended up biting her hand, breaking 3 of her bones in doing so. Shock a kid. What do you think they're going to do? What do you think I would do? Ms. McAuley testified that on the day of the incident, she had been involved in restraining Andre and had administered many of the electric shocks early in the day. She said she had done so in accordance with his treatment plan after multiple people had confirmed he had tensed up each time. Yeah, electric shocks cause that. After GED application, she verbally pointed out the behavior that prompted it. He understood what he was doing was wrong. You must comply. Furthermore, she said he calmed down, his body no longer tense after the shocks. However, she also testified that the staff that day had been unsuccessful in releasing him from restraints that day because of his struggling. While he's being shocked, you're going to struggle. You're going to want out. When asked why Andre had been restrained in the first place, she answered that it was for the purpose of safety and checking for full-body tense-ups. It was my job, she added. God. On cross-examination, Mr. Novotny asked Ms. McAuley while Andre had been shocked the first time, before he attacked her in the earlier incident. She answered that he had attempted to defeat the electrodes, tucking his shirt in and pulling his socks up so they weren't touching his skin. As anyone would. The first time the staff attempted to shock him, the GED didn't go off. They shocked him twice more, which Ms. McAuley said counted as the same shock. In an effort to make the GED actually have its effect on him. In answer to questions as to whether it was true Andre didn't want to be shocked and didn't like to be shocked, she said, I don't know. The end of this case, including closing arguments and the judge's instructions to the jury, will be covered in the next and final blog. So this was a long one, folks, a rather triggering one. I really don't want to commentate. I'm going to have to detox after doing this. So I'm going to hopefully be on Stevie's stream in the chat. I need to detox from this. This one was brutal. I do appreciate your time this afternoon, folks. This case and this Center is important. They are still doing what they did to Andre McCollins. Food deprivation, making people earn the right for food, earn the right to go to the bathroom, earn the right to therapy, being shocked with the GED bags on their back, strapped to their arms, their legs, their torsos, and also the 4-point board. So please, folks, this is critically important. Share this on all your social media. Help us with the algorithm get these videos out there by liking, commenting, and subscribing. I do appreciate your patience this afternoon, and I hope you have a good one. Goodbye.